read the appeal statement.
Thank you, Chair. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson Community Review Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of certiorari. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met.
All right. It appears 1, 2, 3, 4. Appears we have a quorum. And the first thing we'll take up is the board nominations for officers for this year. The nominating committee, which because of expirations of terms, ended up being me. And so I solicited input from members as to what position they would like to be considered for. And the shook out that we basically only had one person interested in each of the positions. Sean Witzel for chair, me as first vice president, Walter Searcy as second vice president, and Heather as our secretary. The procedure under our bylaws is that any member may make nominations, and so you're not in any way limited to the recommendations of the nominating committee. So at this point, are there any further nominations for the board? Mr. Searcy. Nominating committee. All right, do I have a second? Second. All in favor say aye. Aye. All right. Then do I have a motion to approve those, to elect those individuals to their positions I announced? Second? Okay. All in favor? Aye. All opposed? Okay. Those will then be our officers for the coming year and also members of the executive committee. Additionally, at our last executive committee meeting, Member Wynn, it was decided Member Wynn would be the first alternate for the executive committee. He would only vote if there was another member, since the bylaws specify the 4 members of the executive committee. And Mr. Wetzel and I have decided, had a discussion, and he will take over as chair at the conclusion of the meeting. All right, moving on to the next order of business is the approval of the minutes. I hope everybody's had a chance to read over the minutes of what would have been the December meeting. Sir.
Move the approval of the minutes of both the December and January meetings. Second.
All in favor? Aye. Any opposed? Motion carries. All right, chair remarks. I don't have many remarks. I would welcome our two new members, and I guess we've missing the one of them, but I would ask Ms. Westbrook to welcome, and could you just give us a brief outline of what you do? And
Hi, everyone. I am Tanisha Westbrook. I am a business owner here in Nashville with a background in accounting and, of course, entrepreneurship. I also do a lot of community building and work in the Nashville community, especially when it comes to civic engagement. So I'm looking forward to serving and learning from each of you. I'm excited about the work that we're doing.
all right. Well, on behalf of all of the board members, welcome, and we look forward to your active participation. All right. Do we have any public comments? Okay, no public comments. Then we'll turn to the executive director's report.
Okay, I'm glad to see you all. I know we had a tremendous storm, and I know that some of us had our lights out. Joe seemed to be the longest running, had the longest record of no electricity, so I'm glad that you're here today. And so let's go to some of the most pertinent things on here. So, of course, you just did the slate, and what we have is Sean Witzel as chair. I just want to say this for the record. Sean Witzel as chair of the board, Joe Brown as first vice chair, Walter Searcy second vice chair, and Heather Michelle as secretary, with Mark Wynn being a executive member at large. And that would be is that the fifth member, Brazil?
That's
Ross,
correct.
I'm sorry. Okay, thanks. All right. Just a little bit about what's going on within the department. We have a department head meeting. It's also for elected officials. It's scheduled usually on the last Thursday of each month. It will be this month, February the 26th. The NCRB, we filled 2 compliance monitor vacancies. We still have 2 positions that are vacant. One is the intake coordinator program. We call it the program manager. And we also will have a transition with our administrative assistant. So we'll be looking to fill those positions. And we're going to do that pretty quickly because we want to do that before the budget expires for this fiscal year. As it pertains to complaints, since our last meeting, the last meeting that we had was December the 15th. And so we have had 15 civilian complaints since that last meeting, and we've had 2 commendations. I also sent you all the last responses from the chief of police, which happened in January, and that was for 5 cases. And so those cases, I sent you his responses. Those responses have now been uploaded to our portal online. And I also sent him an email related to cases that are still outstanding. So he's received that, and hopefully we can work through those and get figure out some dates on when they will have those completed, since I hadn't received any extensions at this point. For the MOU, Frank sent me over the MOU, the last draft version of the MOU, and I haven't had the opportunity to talk with him about it, but I've reviewed it, and I'll get with him hopefully tomorrow, sometime this week, so that we can get that moving forward for the update to the MOU agreement. Did you want to talk anything about the changes, Frank? Is there anything specific that was different that we hadn't said before?
I think all of the changes, there's nothing really substantive. There are some timing changes, and we're pretty close with the police department's wishes, and after review, we'll have something else to report as far as what it is that we ultimately end up with.
Are there any significant differences at this point?
No, I don't believe there are. There are a few things that should make things easier, and something to put on the board's radar. There have been talks with Cindy Gross, representing the police department, about some type of a software that would be used to process public records requests. That software, I believe, is Just FOIA, without a T, Just FOIA. And Just FOIA would enable third parties and anyone making a records request to see in real time the progress of their request. And a lot of what Executive Director Fitchard and her team do is monitoring these records requests, and it could eliminate a lot of back and forth. But we're not going to build that in until it's ready. And I think Chief Deputy Green was the person that was going to be rolling that out. So we'll likely be invited, Jill and her team, to have a presentation on Just FOIA, see if it's something that could work. And if it does, then that will substantively change the MOU agreement. There's some provisions that would be affected, and effectively Just FOIA would replace some of that. That's really the only substantive update.
Oh, go ahead.
FOIA. Yes.
Without the T, JUS.
JUS FOIA.
All right. And so once I get that MOU agreement sent over to Frank, if there's anything, what I've learned over the course of these last few months is we do have a few gaps in our processes that we've noticed that we're trying to work through. And so once we have that information, and some of that information was translated into our updated MOU. It's just a process stuff. So we'll see what happens with that. Hopefully, we won't have any issues with that. The compliance review, administrative closures, that's the information that's before you for this month. And the budget season is upon us. And so I know the last time we met in January, we discussed two different budgets, and I gave you a proposal A and a proposal B. And then we went back over those, and I sent to you the current one-pager that, hold on one second. All right. The current one-pager that I sent you in this document, with these documents, is what we put into place within the portal. That's what they call it, Norbert. And so that's what we put into Norbert. And what we really wanted was to fill the positions that we had that were vacant. I spoke with Joe about this because we didn't have a chance to vote on it. And so, and then we didn't have an executive committee meeting because of the weather. So we just moved forward with it. Some of the other things that we wanted, like in proposal A, which was the one that had the kind of big number, we put into Norbert as items that we desired for fiscal year 28 and 29. So they're still in there, they're just spread out over the course of 3 years. So if we can get those funded, that would be great. That would bring us up to a total of 16 positions within the office structure, and that would be great. And so I want to tell you a little bit about the vehicle. And so I picked a vehicle. It's a little transition. It's like a van. It's I forgot what they call it, a transition van. It's by Ford. I sent that information over to General Services. And so the director over there decided that there was something that they could do instead of allowing us to just rent vehicles, because renting vehicles have become kind of problematic, because when you want a vehicle on the weekend, especially in the summertime, trucks and vans are gone. I mean, they just don't have the availability. And so, excuse me, they allowed us to, I guess it's a loaner. I think it's a loaner. And so we were able to get a vehicle, a Metro vehicle. It's a Chevy Tahoe. And so I think we've used it once, and it was fine. You know, I think it will be fine temporarily for what we need. And so we have that vehicle. It's housed in our garage, and we have access to it. And so that part has been taken care of, and so I'm very pleased with that. So just to let you know that. So we don't have to go through the leasing process again. So, but they still put this 4% fund, this request for a permanent vehicle in the budget. So whether or not it gets approved, we won't know yet until the process happens. And so it would come out of the capital budget. And then if you noticed, in our budget, we had contractual expenses. There was a little back and forth with us. We have a budget meeting, as I stated. I don't know if I told you, but we have a budget meeting scheduled for March the 2nd with the finance team. And that is to just kind of go, I guess, get a closer look at our investment request. I will tell you that what wasn't included in the years prior, we have a storage space, and that storage space is $700+ per month. And so when they were calculating our rental expenses, they never included that amount of money monthly. So it's been coming, once we did all the figures, it's been coming, at the end of the year, comes out of other object codes. But we did ask for it in this budget. That's, I think it's 8,000 some odd dollars. We did ask for that to be included with our rental since the agreements are together. So we'll see. It is a contract that we have. We just have not had it funded. We were only getting the funding for the rental costs, not the storage. So anyway, so we did ask for that. And then our case management system, and then outside legal counsel. So to have that funded as well. And we figured out, based on Brazil and Clark's, their invoices, what that looked like over the course of 12 months. And so that's pretty much our budget increase. Did you have any questions about that? Okay, perfect. All right, and so community outreach and engagement. Thursday, March the 5th, we're having our annual youth summit at Stratford STEM Magnet School. We've invited, we're partnering with Stratford, as well as the police department will be there. And Ms. Cash has, reached out to so many people in the community. And this will be with the Criminal Justice Academy at Stratford. And so you guys are welcome to come. It is in the middle of the day. It's from, I think, 10 to 2. So that's it on that. It is next Thursday, March the 5th. The NCRB research team is finalizing our annual use of force report. We presented that to you, I think it was in December. They're still working through that, and the report should be finalized, or at least the draft version that they want to present to the public. Once we get that, we'll send it to you for any feedback or input, and then we'll start the process of having our community meetings to have the community come in and talk about that like we've done in the past. That's not a new process. And then, of course, training and development. NACO is hosting, which is our national association, which you are now all a member of. Excuse me. They are hosting their annual conference this year in Louisville, Kentucky. I went to Louisville at the end of January for our winter board meeting and to look at the facility and, meet some of the different people in Louisville who are on the ground who will be supporting this. And currently, we've slated a couple different people for the keynotes and the opening speakers. So that's still in progress. But I will say that it's not that far. It's only like 2 hours, so it was good to be able to drive. Although it snowed while I was there. It was freezing too. But anyway, so that meeting is November the 8th through the 12th. And if any board members are interested in attending, you need to let me know so that I can make certain that we put you down when we start doing the process for that. That is the winter meeting, the annual conference in Louisville, Kentucky. And that concludes my my executive director's report. Any questions? Mr. Oh.
Which hotel, the Hyatt or the Golf?
The Marriott, the Convention Center Marriott downtown.
And that's November what?
November the 8th through the 12th.
All right. I see we've got our last new member here, Mr. Schroeder. Would you like to make a couple comments about your position, background, any objectives you have? So just general comments.
Sure, I'm happy to do that, and I apologize, I went to City Hall, which is not where this meeting is being held tonight. So here I am. My name is Ben Schrader. I am the former chief of the criminal division at the U.S. Attorney's Office here in Nashville. I was a federal prosecutor for about 15 years, and during that time, worked with a number of members of law enforcement. Before I was at the office here, I was at the office, the U.S. Attorney's Office in the District of Columbia, so also work with a lot of local police officers up there. So have had an opportunity to work with officers, with victims, investigating a wide variety of crimes, and just hope that I can make a contribution to this board.
Yeah, I think you appeared before me when I was a magistrate judge for a few times.
I certainly did.
All right. Let's see. We have a draft resolution dealing with how we're listed in Nashville Hub. So
Frank?
if our executive director can advise us what's happened with that.
I'm going to pass the mic over to Attorney Brazil for that information.
All right?
Yes, very simply, and I believe this was circulated to the board. It's an ongoing issue that we are listed, well, the link in Hub Nashville to file a complaint as a citizen is listed in the miscellaneous section. And I believe our executive director had conversations with someone about why this was.
We're listed under miscellaneous in the police department, as I understand it.
Inside Hub Nashville, there's a
Right.
number of links and categories.
Right.
The place that would make logical sense for us to appear would be right where OPA appears, where you file a complaint. And that would be under public safety. Well, but if you scroll down to miscellaneous, which has a number of different access links for anything under the sun, you can find there a place for a citizen to file a complaint. So this was an issue that didn't really have an easy fix, and it came to our attention that there was a request by the police department for us to be listed under miscellaneous. And so we have drafted a resolution that would go to the subcommittee, I guess it'd be on public safety, for consideration, and that was circulated, and I'm available to answer any questions.
Okay.
Is there a vote scheduled? Is it yet?
I do not believe so. I'm waiting for final approval on it. We were going to take it up at executive committee, but
Was there a reason given to why the police would request for us to be in that miscellaneous section?
to my knowledge, in the correspondence I reviewed, there was not. We just learned that Deputy Chief Green instructed that we be listed there.
So essentially, this resolution would make it a council action, and that would overrule any police department assigning us.
Sure. It's unclear why the police department would be weighing in to where, you know, a public-facing link would be located on Hub Nashville. And it's concerning when it's the entity that oversees concluded OPA investigations. But I think that taking it to, council ultimately has the determination for anything related to Hub Nashville, and the right subcommittee could vote for it to be so listed, and that's what we intend to
Then
do.
if we have a motion that's approved by the board to submit the draft resolution, then it would be submitted.
It would be.
All right. Do I have a motion then that the draft, the proposed draft for council action be approved and transmitted to the council to have us listed as our council has advised?
So moved.
Okay. All in favor?
Aye.
Any opposed? Motion's then approved. So you can submit the draft, the resolution to the council, and hopefully at some point, they'll take it up. It's probably not the highest priority for the council, but we'll have it over there.
Well, I just want to say, it's already difficult that the community has trouble, with understanding that that we are still here, that although we went through an abolishment and a preemption, it doesn't make sense to me that the police department would be interested in us being under other tab. It just makes it more difficult for citizens to find our services. It is nonsensical that Chief Green would be involved in this, and the mayor's office directed me basically to get with him. And I don't understand it. My question to them was, when did he become the spokesperson for Hub Nashville? And so I think that the council, I think that this is, I think that this is an important matter. I think it should be escalated. I don't think that it should just stay weighted. The fact that there's this, I don't know why this challenge is even a challenge. Our agency should be listed under public safety, and we should be easily accessible to citizens of Nashville.
Okay, well, hopefully this resolution will, or proposed resolution to the council will put an end to that.
I hope so.
So just to be clear, it goes before the Public Safety Committee first? Is that the route that it takes and then goes to council? I just want to make sure I'm understanding correctly.
Well, that's to be determined. I would think so, and that's certainly who I'm going to send it to,
Okay.
is the chair of the Public Safety Subcommittee, and with a request that they advise the quickest route to put forth the resolution. And if you know a better method, absolutely.
I was just going to ask the board, is there anything that we want to ask of the community to get behind this action?
Well, it'd be nice to have the community contact their council person to support this. I mean, you're right. In a perfect world, the police department should invite us to be part of their website.
That's correct.
If you want complete transparency, that's what it looks like. I'm like you, I'm not sure why they wanted to put us where we couldn't be seen on Nashville Hub. But if, we want the community to support this, and I think they would, is ask people to call a local council person and contact them about our resolution that we proposed, that we now be part, that we be visible, if that.
Correct.
Instead of.
I agree.
Under miscellaneous. We're not miscellaneous. This is not
Right.
miscellaneous duty here.
Correct, and to be clear, that we be visible under the logical location for us to be visible. I mean, it can be argued that it can still be found, but when you read the public safety subcategories, one of them is file a complaint with the OPA. It makes logical sense for an alternative route to be file a complaint with the Nashville Community Review Board. And I'm not sure if we were previously listed there and this was a move.
We were never we're new to Hub Nashville. And initially, when we got the information from the person that handles Hub Nashville in the mayor's office, she said that that they would put us in the public safety category. And then somehow this ended up in Chief Green's lap for some reason. I don't know. And like I asked, I'm trying to understand how he's involved with Hub Nashville. And then they said, well, you have to work with him about it. And so I'm not really sure why,
I'll say one last thing. As members of this board, we're all residents of Davidson County, so if we're going to encourage the community to reach out to their city council person, I think that as members of the board, we should all do the same.
Thank you.
Next item on the agenda is the memorial benches.
right, thank you. I included a letter here. The last time that we had our meeting, I read a letter from Miss Sheila Clemens Lee. She is the mother of Jacquees Clemens. I read that into the record, and the Parks Department we worked together, and they were assisting with this process. They've been working alongside, kind of in the background, on what it is that we could do. And then I think I brought that to the board the last time that we were here, and or in our executive committee meeting, and talking about the price of the benches. And so initially, when the Parks Department and I had a conversation about it, it was a very expensive price. And so they were able to negotiate with some vendors to get the prices down. That's what you see in the letter that I've attached. And then some of the things that, such as the maintaining of the bench in the parks, they said that they would throw that in and not, they would handle that. And so I think that we have a really good price, and we can move forward with that. But I wanted to make certain that I brought it back to the board for your approval, because their meeting is, I believe, next week, on the 3rd. And so Ms. Clemens Lee, Ms. Hambrick is not going to be available. This would be 2 benches, one for Daniel Hambrick and the other for Jacquees Clemens. They're in 2 different locations, I guess near the trees that I named it. I told you what parks. And they have already the Parks Department has already been in touch with them. And so this can move forward. I just wanted to make certain that I was being judicious in bringing it to you all for your vote. And so you got the letter. The letter kind of spells out, they asked me to write a letter to the Parks Director, which I did. I included that in this package. And yeah, if you have any questions, you can ask me. And then if not, I would ask that you would take a vote on it so that we can move forward.
And the cost, I wrote it down somewhere, but I can't find it now.
I'm looking for the letter. Hold on one second. It's not in my documents. Hold on 1 second.
I believe it was somewhere in the $5,000 range, as I recall.
Okay, hold on. I'm gonna pull it up. I'm gonna pull it up. Let me just pull it up.
$5,435.60. So, sir.
No, you're fine, you're fine. I just want to make sure I understood, because I wasn't part of the previous discussions.
Okay.
Why these 2 individuals in particular?
Yeah, sure. Jacquees Clemens was killed by a Nashville police officer, Jason Lippard, in February of 2017. And that particular shooting sparked extensive outrage in our city. And during that time, there was a coalition of community members throughout Nashville and Davidson County, all different faiths, all different ethnicities, that moved forward with, they were requesting police oversight and accountability. And during the time that they were in the process of working through that, because of the death of Jacquees, Daniel Hambrick was murdered by an officer, Andrew Delkey. And so the coalition moved forward with a referendum vote, and the citizens of Nashville, 135,000 people in Nashville, voted to have a community oversight board. And so Ms. Clemens was saying that we're coming up on the 10th year of her son's murder, and she was had received confirmation in regards to having a bench from the mayor's office. And so, and then they made some changes to what it looks like to have a bench and all of that. And so this is moving forward because of that, what happened with the mayor's office and the agreement that they would have this. And so we, because the funding is, they didn't have the funding, we asked that if we could provide it as a grant over to the Parks Department. And I can read the letter into the record. Hold on 1 second.
The letter dated February 13th.
Yes, the letter that I included. Do you have that? Yes. Can I see, do you have the copy of the record? Oh, the letter? Oh, thank you, then. Thank you. Dear Director Odom, I'm writing to formally request approval of an in-kind grant to the Metro Parks for the purchase and installation of 2 memorial benches in Kirkpatrick Park and Watkins Park in memory of Jacquees Clemens and Daniel Hambrick, who tragically lost their lives in Nashville, Tennessee on February 10th, 2017 and July 26, 2018, respectively. The memorials would serve as peaceful places of remembrance and reflection honoring 2 individuals whose loss has deeply affected our community. The benches would stand as symbols of Nashville's ongoing commitment to strengthening police and community relationships, while serving as historical markers that ensure these lives and the lessons learned are never forgotten. The Community Review Board reviewed this matter and concluded that funding these memorial benches would serve the community and city of Nashville by fostering continued trust building between residents and local institutions. Respectfully. Thank you.
Do I hear a motion to approve an expenditure in that amount for the benches?
Move the approval of the motion. I moved that we approve the expenditure for the benches.
Second.
Any discussion? All in favor then?
Aye.
Opposed? Motion carries.
Thank you.
All right,
Question.
sir.
Is there a ceremony or anything that's going to be, that's going to go along with that?
I think we can plan one. We haven't discussed that yet, because I think it's gonna take a little while. It has to go through it has some other, like, bureaucratic stuff to go through. But when it is, I'll let you guys know.
Thank you.
All right, I believe we're now down to the various closures and case reviews.
That's correct. So we start with the closures as usual. I just want to tell you all just a little bit, we're doing something a little differently because we're taking January's agenda information and putting it into February. So for today, for closures, it would be consent closures. And how we do that, just for the new board members, is it's just a consent agenda for those. And so they just take a vote. We're not going to read over any of those cases. And so we have 4 cases for the consent closures. We usually do this in a slate. I will tell you that Mr. Schrader is going to recuse himself from this vote because of a conflict of interest. All right? All right, so it's CC 2025-5128, CC 2025-8463, CC 2025-004, and CC 2025-005. Those are the cases for closure.
All right. I believe they were sent to each of the board members. Are there any particular questions? As I reviewed them, they're basically Rule 16 that there's still criminal or investigations, and so we're not able to access the material under our MOU, and so therefore we'll administratively close them, but upon conclusion of whatever criminal proceedings are involved or litigation that's involved, we can, as needed, reactivate them. But this just takes them off the active case because at this point, we don't have the necessary records to reach any conclusion. So, do I hear a motion then to administratively close the 4 cases cited?
Well, I'll make that motion that we administratively close, those 4 cases.
Second. All in favor?
Aye.
Opposed?
Unready.
I'm sorry?
I should have said, I should have voiced my unreadiness. Before the vote.
Okay.
But, the query is, where do we have a table that these go to? What file do they rest in while we're awaiting the adjudication of these cases?
Repeat your question?
Yeah, where do the cases go? We administratively close them temporarily. I mean, that's what we're doing, because we can bring them back up should the litigation, warrant such, the outcome of the litigation warrant such. So where do they go in the interim?
The cases, of course, they're in our office. We send out a letter to each one of the complainants and let them know why their case is being closed. And then secondly, they go on our portal. And so that information is still available for anyone to look at, the administrative closures as well. But they just, I mean, there's no other place but they rest until a person decides whether they want to open them back up. And then the closure process is after 12 months, it is a closure. And, I mean, there's no time limit for them not to bring it back, if that's what you're asking. Maybe I'm not following you.
No, it was much more bureaucratic query
Okay.
than what substantively happens to it.
Okay. Oh, I know what you're saying. Okay. Never
I'm
mind.
just wondering how we track that. And how parliamentarily, what are we doing? Are we moving it to table to be considered sometime subsequently? But
Yeah, I understand.
your effort at explanation satisfies my unreadiness.
Well, just because we close a case, those cases are all contemplated. I mean, just because when you get a case that's closed, we have thought through it and whether or not it is a case that we could still move forward even without the complainant. A lot of these cases that are being closed, if you recognize, are Rule 16 cases. I have several Rule 16 cases that are sitting on my desk right now that I don't believe are Rule 16 cases. I believe that the police department continuously uses Rule 16
Sure.
as a way to administratively move cases and close them, even though these are administrative closures that have no attachment to an open criminal case, which is what Rule 16 under Rules of Procedure, a criminal procedure is connected to.
But
And
that's
so
not the
those are the
case.
types of cases that I will be bringing forward that that we have had sitting for a while. But I don't believe, I mean, they just are there's some contradiction there.
But that's not the case in any of these 4 cases.
No, in these
These
four
4
cases,
cases are legitimately Rule 16 issues. Is that correct?
if they're presented, then they are, yes.
All right. Okay. Fine. I interrupted your vote. Joe, did you take the vote and you just
thought I
tolerated
did, but
my
no.
post-vote discussion? Okay, all right.
Right.
Good enough.
Yeah, they do remain, they can be reactivated, but they're closed for now. All right. Then we need to take up the actual cases for consideration and a vote.
All right, let's see what we have here on this agenda. All right, the first case that we have is the case that I will present. It's CC 2024-018. This is the case of CC 2024-018 against Officer Benjamin Williams. The allegations against the officer is courtesy, honesty, and truthfulness, conduct unbecoming. The summary of the complaint allegations is on February 12, 2024, Ms. Johnson and Ms. Davis, hereinafter referred to as the complainant 1 and complainant 2, reported they had a dispute with their neighbor regarding the neighbor's dogs running at large that escalated with them reporting the issue to the main office of their apartment complex. The neighbor then contacted the police, alleged that the complainants threatened her. When the officer arrived, hereinafter referred to as just officer, arrived on the scene, the complainants alleged that he immediately asked them for their identification without first asking for more information about the incident. The complainant stated that the officer was aggressive, rude, unprofessional, and threatened to arrest the complainants for disorderly conduct. They allege he made false statements to the property manager where they resided, which led to them being evicted from their apartment. I reviewed all of the evidence in this case, which there was a lot presented. I will say that the OPA investigator did an extremely well job with the questions and the follow-ups for this particular case. And so I'm not going to go through it. It's a very lengthy case. You guys have read it. And I will say that during this investigative filing, which is really centered around the officer, acting in a civil matter. And so throughout this case, when I reviewed it, I listened to all the witnesses' testimony and their interviews. I also listened to the officers' complete recorded interview with the OPA sergeant, as well as looked at all the body-worn cameras. And so the NCRB review shows that the complainants contacted the NCRB they contacted us to report that they had been evicted from their apartment because the officer filed a false report when he was dispatched to their location for a dispute with their neighbor. And a neighbor who allowed her dog to run unleashed, 3 dogs. They said 3 big dogs. And so there was this back and forth with the officer when he showed up. Apparently the neighbors had a dispute the night before. It escalated into one of the neighbor that owned the dogs calling the police the next day in the afternoon. Maybe 3 or 4 officers showed up to the scene, but at the time that the officer was talking to all of the complainant and the witnesses, there were 2 officers there, and they went back and forth. The complainants and the officers, and it escalated to yelling at one another. It could have been a great opportunity for de-escalation. That did not happen. And instead, it just persisted, and the officer began to yell at them to go inside their home and threatened to arrest them for disorderly conduct. The issue in this case, in my opinion, was when the officer went into the apartment and spoke to the property manager. And his conversation with the property manager would appear that he was acting in a civil matter, just like it was the questions that he brought up to the apartment manager. He led the conversation with the apartment manager. And although it may seem like, based on what I listened to, that the apartment manager had some other issues, of course, with the complainants, because they have been, between the complainant and the witness, they have been going back and forth to the apartment complex, reporting on each other. My issue with this case, the OPA's conclusions were that the officer, they exonerated him for acting in a civil matter, and they sustained the courtesy. It said Officer Williams spoke to the department manager about a 3-day eviction due to the potential danger posed by the complainants, and for that reason, Officer Williams was exonerated from that allegation. And then number 2, for the courtesy, they sustained that. They said Officer Williams admitted his comment referring to North Nashville was discourteous and offensive, and for that reason, the above allegation is sustained. During his interaction with the property manager, he mentioned that the behavior that the complainants were displaying was more for North Nashville. And that was an allegation that when as he was speaking about this, he apologized and said that he shouldn't have said that. He was not referring to race. It was just that their behavior was more connected to what he had, when he was patrolling North Nashville, that was what he had encountered, people yelling and drinking and speaking loudly to him. And so additionally, he was directed by the command staff to attend HR sensitivity training. He completed that 1.5-hour course, and he did that successfully. And so my conclusion here was, after careful review of the OPA investigation, it is determined that the investigation itself is thorough and complete. However, the recommendation of exonerated for acting in a civil matter is not supported by the evidence. Throughout this interview, this officer said that he had done numerous things. Number one, he approached the apartment manager. He told the apartment manager that there were multiple people living in the apartment, and he wasn't, when asked why he said that, was he aware of how many people? He said no. He assumed that it was about 3 to 4 people living there because he saw 3 or 4 people standing outside. He also said that he believed that the complainants were violent, and when asked why, he said because they were yelling and wouldn't listen to him. He also threatened to have them arrested for disorderly conduct, which does not constitute a violent crime. And so I don't know why he said that they were violent. And so my suggestion would be that the subject officer have remedial training on personal behavior acting in a civil matter. And this recommendation for remedial training is based on the officer's admission that he participated in another incident. This wasn't the first time that he said, that he admitted that he had got involved with some type of eviction of a person. And in this complaint, he's also speaking to the property manager about evicting residents and participating in that process. These 2 incidents occurred within a 6-month period. And additionally, as I said a moment ago, in his interview, he used the term violence as the reason for his contact with property managers. But in this instance, no criminal investigation was opened into the allegations lodged by both parties related to threats of violence against one another. And moreover, the officer stated the complainants were violent, although he only threatened to arrest them for disorderly conduct and not a violent act. And so those complaint allegations for truthfulness, OPA did not address that allegation. And the conduct unbecoming of an employee of the department, OPA also did not address that allegation. I will say, for honesty and truthfulness, I didn't, in his report, after reviewing the body-worn camera and video footage and incident reports, there's nothing in the incident report that would support the allegation that he made false statements in his reporting of the incident. And I will also note that when I looked over his report, because in this particular case, he stated that he was going to write a strong report that would assist with, whatever the apartment manager wanted. It was factual. It was based on what I saw in the body-worn camera footage. So I don't think that there was any untruthfulness. I think the major issue here is the acting in a civil matter. And so that concludes my report. I'll take any questions.
So the remedial training, could you explain that to me again, what it was he was, what he had completed?
So the command staff, when they went over this case, they directed him to attend HR sensitivity training in relation to his statement about North Nashville.
So what do we know about HR sensitivity training?
I'm not sure. I don't know. I received the documentation that he went, but it didn't have any particulars. But I can ask for the curriculum for that.
I would be interested in it. I think the board should be too. I think you probably are. We've had this conversation before about mitigating bias and what that looks like within any agency. As a matter of fact, I think I may have brought it up in one of our past meetings that IECP's got an entire standalone policy on anti-bias policing, which has been accepted by agencies all over the country. It might be that in the future, we have our research folks take a look at that for a recommendation, because part of our duties under the new state law is that we make recommendations for policy like we did the sexual misconduct policy. And I think at some point in the future, we might want to consider, because of these cases, that we make a suggestion to Chief Drake and the department to maybe have some classes on mitigating bias and stereotyping, just to cover the base. And I'm not judging this officer on what he said about North Nashville. I worked North Nashville most of my career as an officer. So I don't think there's any mystery about who populates North Nashville. So we don't need to act like it, well, for me personally, I know who lives in North Nashville. Well, a lot of white people live there now, but because of gentrification, but it sounded like his bias slipped a little, I suspect. And I think we might want to revisit that as a recommendation for training for the police department.
All right, thank you.
Sure, I just want to make sure I kind of understand the purpose of the remedial training here, because, you know, you have an officer who arrives sort of to help resolve this dispute. There are allegations of some violent conduct, dogs kind of on the loose, allegations of a weapon being brandished. And I want to make sure I kind of understand what the sort of criticism is of the officer's conduct, because is it that it would have been fine if he had gone in to speak to the landlord and they had sort of struck up a conversation about what the landlord could sort of try to do to mitigate the situation? Or in your view, is the issue that the officer went in sort of intending to suggest that the solution here was to evict one set of parties? Because, you know, if you're the officer just trying to figure out what to do, and if what you're being told after what happened is you shouldn't have even broached the subject of eviction, you know, I guess I don't know what sort of an officer is supposed to do in this kind of situation where he happens to kind of go in and talk to the landlord. But maybe it sort of unfolded differently. Maybe, as I understand it, he was sort of potentially suggesting that that's what the landlord ought to do.
Yeah, I think the officer, when he went into the office, number one, he was upset. And then the first thing that he did was started having a conversation with the property manager and suggesting, well, there's multiple people living in this apartment. And then she says, yeah, I know them, and, you know, this conversation back and forth. And I believe that he then goes into, they're violent. They're really violent. And she says, well, what do you want to do? He mentions a 3-day. And he says it first. She doesn't even mention anything about eviction. He does. He says, yeah, well, you know, maybe this is a 3-day. And so, and she's new to that apartment complex, not that she's new to property management. And she says, well, we can do a 3-day if you know, as long as you write it up really strongly. And then they go back and forth about this. And he says, well, I can write it really strongly, but, you know, I'm going to write it truthfully. And she says, well, if you write it, I'll make certain that we get it done. And so this conversation that I think is, you know, very suggestive on his part about this eviction process with these two people, and the fact, and then he goes on and on about their behavior towards him and yelling and screaming at him. And, you know, so for me, I think the remedial training is to train. I don't think that the policy is strong enough as it pertains to acting in a civil matter. If you look at the policy here, the policy just basically says, employees shall not take any action in any matter not subject to criminal prosecution except to prevent the violation of a law. And so officers can have these conversations, and the questions that OPA asked him were valid. And they asked the questions, they followed up and asked him why, did he even do an investigation related to this threat of a weapon? Because both parties are saying, no, it's you, it's not. So they're both placing blame on each other on who brandished a weapon the night before. And so the complainants are stating that this witness who said that they brandished a gun towards her, she did that because the next day, when they started like going back and forth with her, she was upset and they told her they were going to report her to the property manager. So this was a whole bunch of back and forth, he say, she say. And the officer decided, and even I think the investigator, OPA, asked him, well, did you do an investigation into this? What would make you think that these people were violent? And he didn't really have a good answer. He just said, because they were yelling and screaming at me. So, did I answer your question?
It did. I mean, I think, to be candid, I mean, I think it's kind of a close call here. This is an officer, I think, trying to figure out kind of what to do with the situation. But at the same time, you know, I don't know whether it's sort of beyond the bounds of the policy as written to sort of talk about the option of evicting folks. I do think it is significant that there was I wouldn't call it a similar incident, but another sort of eviction-related incident 6 months earlier. So I guess what I'm saying is sort of the purpose here is just to make sure the officer is aware of what the policy is and is properly trained on the policy, because there have been these two sort of eviction-related incidents that have arisen.
Yes, I agree. And I think that one of the things that is important here is the policy it doesn't have a lot of information. It's written really ambiguously. It's a policy that needs to be strengthened. It should have more information. I don't know how they're training officers on how to interact with property managers. I feel in the world that we live in now, an eviction for violent behavior that hasn't been supported by violence or any type of, you know, this was just an allegation that there was no support to say that these women were violent. They now have this on their record. They will not be able to get another apartment if you have an eviction for violent behavior. And so if this is going on and our police department is participating in this, I'm concerned about that. It's a legitimate concern that people in our community would be evicted for an allegation of violence that has no support documents or anything to support that this was some kind of violent behavior that had not been investigated. So on the witness side, they're saying, oh yeah, they pointed a gun at me or they had a gun, and they're yelling and screaming. We don't even have any guns, and they're back and forth, and instead of investigating that, we're trying to, I just feel like this is a problem that we need to address before it starts escalating. I don't know I haven't had any other evictions that I can recall. Maybe I have, I don't remember, but this allegation to me was, I feel like there is opportunity here for the police department to have a training or some type of, I don't know, remedial training, or create a stronger policy here related to what it is to act in a civil matter.
So I can tell you the past, as part of the recruit training, it may be different now, in the law courses, each recruit gets a copy of the Metro Landlord Tenant Act, because in anticipation of when you get out on the street, you're going to be dealing with a lot of these kinds of tenant-landlord issues around violence and drugs and destruction of property. So there was a time when it was part of the curriculum to teach them the basics, including, the emergency 3-day eviction notices. So this wasn't a public housing development, was it?
No, this was in a private,
Okay.
This was in a private apartment.
And it applies to private.
Yeah.
Public's a little bit different thing.
Yeah.
Was the other side of this, the dog owner, were they evicted as well, or?
No.
Okay.
And that's how that North Nashville comment came in. The North Nashville comment came in because he's talking to the property manager and saying, that kind of behavior is not acceptable out here. That happens in North Nashville. And and they're in Madison. I'm like, oh, okay. Well,
I read this one 2 or 3 times, and frankly, it's a little hard to follow,
okay.
but I had a little bit of a problem on the recommendation,
Okay.
the officer received an hour and a half of training on conduct and effect. And I was a little perplexed as to what additional training would be there. Was that intended to be just the fact that he started advising the property manager? As I say, I was just a little confused as to what had occurred, and obviously if the dog owner had the father of her child bring a gun, that would have been a more serious matter
Correct.
on the dog owner. I just was kind of left a little confused, but what we were going to recommend.
Well, I think it was confusing. And I think that there were two officers there, and it would have made more sense for one officer to talk to the witness and the other talk to the complainants so that they could have got a story instead of all of them just there yelling at each other. And he was unable to de-escalate this and handle this situation. And so my only suggestion, and I mean, there's not a whole lot that we can do here except for get some more training on this policy, and that may not even be something that we can do. I'm just, you know, the fact that we have to do, I feel like strongly that we have to do something about this and at least bring it to the attention of the chief of police that this is happening, and that maybe in-service training on that would be acceptable. You know, they have an in-service or they have yearly training, and maybe this is one of those topics that they need to take up. You know,
Member Wynn asked about what was in the training the officer got. He got an hour and a half of training.
Well, those are two different trainings, Judge. One is the sensitivity training is specific to his North Nashville bias comment. What I'm requesting is training related to 4.20 under personal behavior, and it's acting in civil matters. And it's one sentence.
Okay.
That's
so
what the policy is. It's one sentence.
I would think we might need to make that, our recommendation, a little more specific as to what we're recommending. That we're recommending that officers be given additional training in when they should become involved in potential civil matters. It seems to me like we
Yes.
need to,
That's
we
right.
need to sharpen up our recommendation as to what we're.
Okay. Well, you want to work it out? And I think that's what I think it's a good opportunity here to sharpen up that recommendation.
Unfortunately, I don't have the actual language. I didn't bring that with me, but, Member Whitson.
My question is, are we recommending this for this one particular officer, or is it something that we're recommending across the board?
I would say, go ahead, Ben.
Oh, I was going to say, the case we have before us is this one officer. So we don't really know anything more about anybody else in other situations. So my recommendation would be that we restrict it to this officer, given the facts we have before us. And I guess just to go back to the judge's point on the recommendation, I mean, I read the recommendation to suggest that this officer have remedial training specifically on this policy manual. Is there some way, in terms of sharpening it, is there some specific sort of notion that you're thinking of? Because the recommended action is with respect to additional training on this specific policy matter, which I think is what we're sort of talking about. I don't know if there's just an ambiguity that I'm missing.
No, I think that's accurate. That the policy doesn't give us any room. Go ahead, Mr. Cersei.
I think I'd take a different view from, as we would say in a courtroom, my esteemed colleague, as I now want to punch it. I heard you read the one sentence policy, and I believe such a policy is doomed for future ambiguities. And if we're in a position where we can prophylactically address this, then we should. And I would suggest that as Sean's query implicated, that we really consider a policy that is not exclusive to, or to address this, not exclusive to this one incident, notwithstanding that he has two failures. So not this one incident, but this one individual. And I think we're well within our capacity and authority to do so. When we see that there's, in fact, you have a failure of policy, that there's no reason to believe that training in the future regarding that policy is going to make a difference. So I suggest that we instead take the broad brush with this one and not limit it to just a focus on this one individual in this one incident.
Would you have any particular language you would suggest then? I don't disagree with you.
Yeah. Excuse me. Yes, go ahead. I defer, Ms. Teresa. Yeah.
So as far as language, what I'm thinking about is process. So is there a defined process for how officers deal with civil matters? First is the definition of what a civil matter is, and that policy doesn't clearly define that. And then is there a way for us to find out what their process is when they are out and they come across a civil matter? Can we get access to that information? Is there a way that we can put that in our recommendation to find out more?
I typically don't comment on these, but I would say, just from a legal standpoint, we should encourage the board to review the whole of 4.20, the policy, because we're talking about one subsection as it pertains to civil matters, an eviction being a civil matter. And that's the sentence that we've honed in on, but 4.20 is much bigger, and this is one particular subsection that, and that's not even addressing whether or not it should have been exonerated, because it does appear that involving yourself in an eviction proceeding would be against that subsection of the policy as written. But that's just my only comment, as I was relaying it to the executive director.
We have a Cinderella bewitching hour at 7 o'clock, so I'm going to...
6:30 for me.
Huh?
6:30 for me.
Okay. My suggestion is that we defer this and for a little more information and defer it to the next meeting.
That's fine by me, yeah.
So, as chair, acting chair, I'm going to defer this until the next meeting. So let's take up the next one then.
Good evening. I will be presenting case number CC 2025-8942. And the allegations of misconduct by NCRB against Officer Michael Schlegel are courtesy, responsibility, self-control, abusive treatment, and traffic enforcement. And the summary of complaint allegations are as such. On July 24th of 2025, Mr. Derek Terry, hereinafter referred to as complainant, contacted the Nashville Community Review Board and alleged that on the same date as he traveled to work between Woodmont Boulevard and Franklin Road Academy, he observed two MMPD officers monitoring traffic speeds while operating police motorcycles. As complainant passed Officer Michael Schlegel, hereinafter referred to as officer, activated his emergency lights and began to pursue complainant. Upon observing officer in his rearview mirror, complainant prepared to make a safe stop on the roadside. Despite the limited shoulder space, instead of allowing him to come to a stop safely, officer pulled up alongside complainant's left side and motioned with his right hand for complainant to pull over. Officer aggressively yelled at complainant to pull over. Officer then positioned his motorcycle in front of complainant, which forced complainant to make an unsafe stop and ultimately caused him to veer off the road. As a result of the maneuver, complainant's motorcycle sustained damage. He stated that his brake lever was broken, the engine flooded, and there were visible cosmetic scratches to the bike. Officer informed complainant that he was stopped for speeding. Complainant stated that he received no citation or any other paperwork for the stop. And so OPA investigated this matter, and in their review, they completed interviews with both the complainant and as well as the officer involved. They also reviewed the body-worn camera footage, which showed the officer signaling once the complainant wanted to pull to the right. The video did not show the officer crossing in front of the complainant or acting aggressively. They also verified the speed that the complainant was traveling and verified that he was traveling 59 in a 45-mile-per-hour zone. And regarding the motorcycle fall, the footage showed that the complainant pulled past the shoulder into the grass and attempted to dismount on the high side, which caused the motorcycle to tip over. Regarding the NCRB review, just 1 second. Regarding the NCRB review, the Assistant Director reviewed the OPA investigation, body-worn camera footage, the MMPD reports, and interviews with both the complainant and officer regarding a traffic stop on July 24th of /05. The review confirmed that complainant was stopped by the officer for traveling 59 miles per hour in a 45-mile-per-hour zone on Franklin Pike. The body-worn camera footage showed officer using the LiDAR device, but before pursuing complainant and signaling him to pull over by pointing to the right. Officer's actions appeared to be controlled and professional. No evidence of aggression or unsafe positioning of his motorcycle. Complainant's motorcycle fell after stopping when his foot became caught in his saddlebag, but no visible damage occurred. Officer immediately checked on the complainant, actually assisted him in uprighting the motorcycle once it fell, and explained the reason for the stop. Throughout the interaction, I reviewed, the officer displayed a courteous demeanor, even laughed with the complainant and issued a verbal warning for the speeding violation. MMPD reports confirmed the time, the location, and the outcome of the stop. The OPA conclusion and actions are, OPA concluded that the officer acted with the established policies and procedures of MMPD, and the allegations or policy violations that they found were courtesy, and they found that it was unfounded. They also basically said that when the OPA reviewed the body-worn camera, that the audio did not start due to the built-in 1-minute buffer. The body-worn camera showed the officer pointed to the side of the road one time with his right hand calmly, and after the buffer, all the interaction was captured and verified. The officer never raised his voice or made any aggressive hand gestures. During the interview, the officer did state that he was competing with the traffic noise, so he did raise his voice to make sure that the complainant could hear him. But that is the only reason that he would have raised his voice, to make sure that he was heard. Also, regarding the adherence to policy rules of metropolitan government, to wit, traffic enforcement procedures for enforcement contacts, OPA found that the officer was exonerated in that situation. And so the assistant director did review the evidence in this case with the with the executive director rather, and the officer did not violate in any MMPD policies, and OPA's investigation is complete and findings are satisfactory. OPA did not address the other allegations that were alleged by the NCRB, which were the responsibility, abusive treatment, and self-control. And that concludes my report. I'll take any questions.
Any questions? Do I have a motion that be approved?
I make a motion.
All in favor? Any opposed? Okay, it's approved. Next.
Okay. Since the executive director has stepped away, I'll go on with my second case, if that's okay. I'll present CC 2025-5789. And the allegations of misconduct by NCRB against Officer Natalia Bonket, excuse my pronunciation, I'm going to spell it, Bocanegra, is the officer, and those allegations are deficient or inefficient performance of duties, conduct unbecoming of an employee of the department, courtesy, and documentation of incident and departmental record keeping. The summary of allegations are such: on May 28th of 2025, Mr. Shane Henderson, hereinafter referred to as complainant, emailed the Nashville Community Review Board to file a complaint about what he called the ongoing poor performance and discourteous treatment of officers assigned to the MMPD East Precinct. The complainant stated that several incidents occurred at his home, which included multiple break-ins, hate-based vandalism, and his dog being poisoned. After each event, the complainant contacted MMPD for assistance and received little to no help from officers at the East Precinct. Complainant believed his claims were not taken seriously, which has caused him to fear for his mother and his own safety. The complaint was filed to seek assistance from MMPD regarding these events, as complainant previously attempts were unsuccessful. And so on June 5th, the compliance monitor completed a referral, and that complaint was sent to the OPA. Again, they completed their investigation of the case. They made multiple contacts with the complainant through phone and email, and were initially unsuccessful when trying to reach out to the individual. Body-worn camera footage was reviewed by OPA. They looked at photos. They spoke with the landlord, who raised the drug use or erratic behavior concerns were raised by the landlord. Let's see, prior calls for the service at the address since February 7th, and there were 5 reports completed. In that regard, the OPA completed an investigation on those issues. The NCRB completed a review of the investigation, and the NCRB review of OP's investigation confirmed that Detective Amanda Topping was the assigned investigator, and the assistant director conducted a full review of the case file and confirmed complainant's reported versions. Let me see if I can give you more of a summary than reading the whole. Well, it's not that long. The NCRB review confirmed OPA's investigation of Detective Sergeant Amanda Topping, reviewing the body-worn camera footage on May 19th of 2025. The incident reports the CAD history showing 13 calls for service at the complainant's address. Body-worn camera footage depicted the officer inspecting an AC unit, which the complainant had complained that someone had been tampering with the AC unit. And so the footage does show the officer going to the AC unit with the complainant to view what he called damage to his unit. She also reviewed photos, engaging with the complainant. She also had a conversation with the landlord, who had also made some statements. And so based on the review, the NCRB did agree with the OPA investigation and concluded that the investigation was fair and consistent, and the OPA's conclusions and actions within the established policies and procedures of MMPD, and their actual policy that they looked at was courtesy, and the officer was exonerated for that. And they also, that is the only allegation that they looked at. They did not address the deficient or inefficient performance of duties or conduct of unbecoming of a employee of the department, or the documentation of incident and departmental record keeping. And so again, the officer was exonerated for the courtesy. And the assistant director reviewed the evidence with the case and concludes that the officer did not violate any MMPD policies, and that OPA's investigation is complete and the findings satisfactory. And that concludes my report. Any questions?
Do I hear a motion to approve?
I have one question, Judge.
Sure.
1 second. I noticed in the report that the complainant complained about being stalked. Is that right?
Complained about?
Being stalked?
Yes.
Stalking allegation?
Yes. He said that there was some vandalism to his air conditioning unit and some hate-based crime, yes.
So there's no mention of it being found unfounded or in the report?
No, they did not address that. I think when they finally reached the complainant, they, made several attempts to reach him. The conversation at that point was about his air conditioning unit, and that is what the officer reported to his residents before. But in the initial complaint, he made statements that he had, had these things happen to him, and that they were never addressed by the East Precinct.
Right.
But when he spoke with them directly, his sole complaint was about the air conditioning unit.
I noticed that, and I wanted to just make note of this because it seems to me we're missing something here, because when you make a complaint about something like stalking, the initial report's written by patrol, but it's assigned to a detective, and I don't usually see those reports in our decision. In other words, the patrol officer's not the only one responding. The detective's responding to if it was assigned to the detective. It'd be interesting to see if a detective actually looked at the case, because his complaint is, he's making all these complaints to one of the precincts that never gets any further than that. So who is making these decisions about case assignment? Generally, in the past, like this, because it becomes more, extensive, you have to have a detective look at it. We don't see those reports. Is that something you all are asking for when you ask for OPA? their files?
We received the entire investigation when they returned the OPA investigation. Are you asking specifically, are we asking for?
No, it just seems to me when you look at OPA's report on the action of the officer, it's almost like the OPA now is substituting for the detectives division. Does that make sense?
I understand.
Yeah, I agree with you on that. I mean, we have cases where, cases that I haven't been able to present because as you're digging through the case, it's similar to what you're saying, if there is an allegation about a specific thing that a complainant might say, but if it's also some criminal activity, my concern is that we aren't getting any information OPA is doing their part of the investigation strictly related to the complainant, but whether or not there is this secondary investigation in an open case, we don't have that knowledge. And so that's why I didn't present another case today, because I did not have enough information because if a person makes a complaint, I'm assuming that if there's this police interaction, that there is an open investigation happening here. Or if it's not, then I'd like to know why didn't they move forward with that? So that's similar, and we can ask, but whether or not we would get that information, I don't know if we would or not if it's an open case.
Well,
But it would be helpful to know, I guess, is what you're asking.
well, it would, because you've got a second set of eyes now looking at a potential crime, and if the
Right.
detective says it's unfounded or it should be closed, that would make a difference. It looks like to me the OPA now is becoming explaining to all of us why the case wasn't followed up on.
Yeah.
And then again, we still don't have an answer for this complaint about the prior reports to the station who aren't answered. So there's pieces of it that seem, it's all on
Missing.
the officer at this point,
Yeah.
when there's other people who should be explaining how this citizen was dealt with. Does that make sense?
It makes sense to me. I mean, and you have an option not to accept this and send it back, because we can do that. I mean, I want it to be as thorough as possible. And if there is other outstanding concerns that we could try to get addressed before you make a decision, that's fine with me.
No, I'm not objecting to
Okay.
your recommendation. I'm just saying, in the future, for my purpose, it'd be interesting to see how many cooks are in the stew. Is that, you know what I mean?
Absolutely.
Before we make a decision on the individual officer, because the burden rests on them now. The individual officer, when someone else is looking at it and say, wait a minute, this case is a good case, or this person has got some emotional problem and they're just reporting to police and there's no
Right.
suspect at all. That happens too.
It
So
does.
anyway, just my recommendation.
Well, we have 3 recommended actions. So we're sending this back to the OPA, is that not correct? I mean, it's deficient and insufficient performance of duties. The OPA didn't address that. Conduct unbecoming an employee of the department, they didn't address that. Documentation of incident and departmental record keeping, they didn't address that. So our response then is that we want them to do these things, right?
Right. So this is a good opportunity to have this conversation. So when a person calls our office and makes an allegation, they want to file a complaint, we look through the police manual based on the interview that we have with the complainant, and then we attach allegations to their complaint. When we send that over to the OPA, most of the time, the majority of the time, they talk to the complainant and create their whole separate allegations. And ours just linger out there unaddressed. And so what happens is, in the past, in order to kind of adjudicate those allegations, because OPA did not pick them up, I was saying that they were unfounded, which I don't think is accurate. And so I now am saying, just like you see here, and I've instructed her, to say that these have not been addressed. And they should tell us why they are not addressing the allegations that we are attaching there. They may have a great reason why they're not doing it, but they can't just ignore them, which is what's been happening. And so now we say, these are allegations that have not been addressed. For instance, I'm gonna go back to my case, what I just had, the allegation was conduct unbecoming. And they just disregarded that, although they saw on the video that the officer was yelling and screaming and had lost his composure. And just charged it with discourtesy. So my point is, these allegations are sitting there with no adjudication through this process. And so I think that, yeah, you know, we're notating it. I mean, what else do we do with it?
Well, why don't we send it to the chief?
Well, we do. We can. That's why we have those different things. I mean, I'm fine with sending it to the chief.
You know, with a notation saying that, chief, these things were not addressed. We would like them to be addressed. Would you please instruct OPA to respond to these specific inquiries?
If that's what the board wants to do, we can do it. I agree with you. I mean, they have to be addressed. Now, if in fact our allegations are not correct, they can say that too. They
Right,
can say,
sure.
this is not the correct allegation for this particular thing. We're looking at the policy for the allegations, but you know, I mean, I just don't want us to get into a pattern where they are choosing less allegations. For instance, everything's a courtesy opposed to what it really is. And that's what we see is becoming a pattern and a practice that we're using instead of an officer's behavior, which, you know, people lose their temper, but it's not a discourtesy. It is what it is. And, you know, it's just standing there and they're not addressing those things.
We need a motion.
Go with Frank
Well,
first.
very quickly, would it be appropriate to include in an MOU something along the lines of, in the event OPA formulates allegations that differ from the allegations formulated by the NCRB, they will explain their reasons for not addressing the allegations? Because this may be something that could be fixed with a sentence. This did not match our policy definitions for conduct unbecoming, or whatever it is. But I still feel like not addressed may be insufficient, because maybe it was addressed, but we just don't have any feedback, and it was changed. Should we have some overarching rule here?
We do need to have something in place for it.
Remember when I was just going to say, as well as the executive director said, in previous reports that have been presented, this is really nothing new with MNPD, or excuse me, OPA, changing our policy or our allegations. I think what is new to your ears today is the language that we are using, that it was not addressed. In the past, when we were presenting, we're using the words unfounded, which, as the executive director explained, that's really not the case. It wasn't unfounded, it wasn't even looked at. And so that's probably new to your ears today.
Well, no, the unfounded was the report of the crime, whether the case was legitimate or not. Was that an unfounded report to the officer? That was my reference in that. But, and we don't know, because we don't know who else handled the case. And that, to me, if you're evaluating the entire case, it'd be nice to know who else was involved in it. And we don't usually get those. I haven't heard.
Well, we don't get a lot of those
Got
anyway.
it.
That's why you haven't heard that.
Okay.
But we do have a few that I have, that's why that's why they haven't presented today, because
Right.
of that same issue.
Well, I mean, if you put it in this sense, if I were taking a look at this case inside the agency,
Yeah.
I'd want to know who had the secondary follow-up to the case.
Right.
And what was done. We don't see any of that. We just see, so the burden now is, again, on OPA to be this officer's supervisor, basically.
Right, and it's not OPA's responsibility. Okay.
Cut a little bit short. Member Cersei, you had a time limit, but you had something, or you were about to try a motion.
Yes. I move that we send complaint number 5789 to the chief with the instructions that we've discussed, including but not limited to mandating that we get an explanation from OPA as to why they didn't address those particular charges.
Can I ask a question here? So what's the difference, practically speaking, from sending this, as it's sort of currently proposed, to OPA versus sending it to the chief? Is there a downside to sending it to the chief?
No, I just think that it's a higher level, like you send it to the chief to get a high, a response, OPA. You can send it, for me, if it goes to the chief, then the chief is going to probably assign it maybe to his, who's maybe somebody in his command staff. But if you send it back to OPA, because we've done both. I mean, it's the same response, to be really super honest with you. The response comes back from the chief on one of those kind of letters that you've seen, that I attached in this, that I sent to you in January.
Do we have a second?
Did you want to, Sean, you wanted to say something before the motion, or what?
We're just talking about this, we're not talking about the suggestion.
I just mentioned it.
I think that's a good point, that our executive director just mentioned. I think for purposes of our recommendation, we need to limit it to this, and then that's a separate discussion that we need to figure out how it is responded to when allegations are changed. And maybe it's just a change in designation.
Did we have a second? Okay. All right, discussion. I think we're getting ourselves wrapped around the axle on this one. This is an individual that had filed some 13 complaints, and there was concern about his stability. It seems like the recommendation to treat it as this officer going out there, we could close this out by approving the recommendation of the executive director, and then we can take up as a separate issue our concern that OPA is is reforming our complaints as a separate issue, and perhaps consider whether we would bring that into our
Well, now that
recommendations for the
now that you've
MOU.
spoken out of order on this motion.
Beg pardon?
I said, now that you've been out of order on this motion, we have a motion and a second.
And a discussion.
Oh, is that what we're doing?
Yeah, that's my discussion of it. So I think I'm on sound ground on the discussion.
Yeah.
But pending any further discussion, then all in favor?
Aye.
All in favor to?
Of
Send it to the chief.
Member Surfy's motion. That's the motion.
Yeah.
The motion was a recommendation to send to the chief a request that he address everything delineated as not addressed.
All right, all in favor, then aye. All opposed? Okay, motion carries.
Fair
All
enough.
right.
I do have one thing I want to go back over, for the case, of 2024-081, the case that I read to you into the record. Your response was to keep this, case, I guess, on the agenda for next month. Do you have to take a vote for that?
Yes, we took a vote.
I don't think you took a vote on it. You just made a suggestion. So there wasn't a vote taken in regards to that. And I just need to understand what it is that we're doing with that case before.
That's
So I
right.
know that you want to keep
We
it on
took
the
a vote
agenda
on
for
that.
next month.
Yeah, I thought we had a motion.
Yeah, I thought we took a vote on that.
Yeah, we took a vote on it.
No, we
Well,
didn't vote.
I don't believe we voted to the specific, I think at one point, Member Chair Brown's remarks were, as the chair, we should consider this next week because we have time constraints. But I don't believe we formalized that decision with a vote. And the suggestion, I believe, would be that next meeting, we consider 4.20, the policy, specifically because Member Cersei created or voiced concern about that being deficient and being set up for failure. So we would vote to consider that policy next meeting before we make any sweeping recommendation to the department.
And it's MMPD Manual Policy 04.20.040, personal behavior, V as in Victor, acting in civil matter.
I think the best thing to do is when, as chair, I'll defer that to the next meeting.
All in favor?
I'm just making that a
Okay.
decision.
Oh, okay.
Defer it to the next meeting.
Okay.
Any opposition to that?
That's what I already have.
What happened to the all in favor?
What did they do with 89?
We were in agreement, we wanted to defer it till next meeting.
Okay.
And that one was approved.
Okay.
8942 is approved.
Do we have one more case, or is that?
I think that's everything.
New business?
New business. Do we have one more? Wait a minute, which? For the record, 2024-045, I didn't have enough information at the end, so I will bring that to next month's board meeting.
Oh, okay.
So that's the one that you see on there.
Okay. Well, we'll have several cases for next, meeting. Yeah, any new business.
So, a couple months ago, the Community Oriented Policing Office of the Department of Justice did a highlight report on Metro's professional wellness section and a national best practice on the wellness of officers. And I'd like to explore, and the board didn't have to do it, I can reach out to the director of the wellness program. I think it'd be important if we could have them come and do a presentation to the board on how they've reached that level of a national standard, so we can be better informed when we make judgments on behavior of officers, when in fact the wellness department is directly related to the behavior of officers. I think it'd be important for the community to see it and to hear from them on how they're doing this, how they're taking care of the wellness of our officers. And for us to know how these officers are part of their requirement for remedial training or punishment or whatever it might be. I don't want to call it punishment, but required to reach out to wellness for their behavior. So I just want to make, before I went any further and reached out to the folks in the wellness section to get your sort of approval, that it would be that in the future, the next month or so, we could have a presentation by that department. It's all right. Speaking to the two chairs, outgoing and then the chairs. That's just a quick, I'll see a thumb up. Okay.
Let's do it.
And I want to prepare you all, because I would like to ask them to come and talk to us about, this is really, really important stuff, I think, for us to understand.
Yeah. Thank you.
Okay.
Oh, I guess so.
We'll add that to the agenda then for
Will it?
next month,
Or the coming months, it'll be.
Okay. future meetings.
Yes, sir.
All right. All right, if we covered everything, anything else to bring up tonight? If so, I'll entertain a motion to adjourn. So moved. All in favor, maybe depart.
This is before.
This has been a service of the Metro